Did you know that in a medical malpractice case in New York, if I'm able to get a doctor to admit certain things to me during his pretrial testimony, I stand a much greater chance of winning the case at the time of trial? You want to know what this is about? Come join me for a moment as I show you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and let me explain to you what I'm talking about today. During the course of a deposition, which is pretrial testimony, it's really a question and answer session that's given in the defense lawyer's office. And now I have an opportunity to question the doctor whom you are suing. I have a goal, I have an agenda. I have a series of questions I need to ask the doctor during this question and answer session. And by the way, this carries the same exact weight as if the doctor is testifying at trial. The only difference is there's no jury present and there's no judge present. So we're doing this in the attorney's office, but there's a court reporter there to take down and record all of my questions and all of the doctor's answers. So now, one of the key things I want to establish during the course of this question and answer session is I need to ask the doctor hypothetical questions. Doctor, I want you to assume that the following facts are true. And now I'll go ahead and list an entire series of facts that we believe to be true, that we have evidence to support those set of facts. Assuming that those set of facts are true, doctor, would you agree that failing to do the following thing would be a violation from the basic standard of medical care? Yes or no? If the answer is yes, now I have to ask the doctor, tell me why. And what he's doing is he's telling me in his own words why it would be a departure, why it would be a violation from the standard of care to not to do those things. And now I'll ask him another hypothetical question. Doctor, I want you to assume that these facts are true. In that instance, assuming that those are true, would you agree that not doing A, B, and C would be a violation from the basic standard of medical care? Yes or no? If the answer is yes, tell me why. If the answer is no, tell me why, because I still want to know the answer. This testimony I can use at the time of trial. So it's critical for me to obtain this information now during the pretrial phase. And ultimately, if I am able to show all of our facts that we are claiming to be more likely true than not true, then guess what? The doctor has now admitted during the course of his own testimony, in his own words, that there was a violation from the standard of care, causing my client harm. So it establishes from the doctor himself that there's liability, that there's wrongdoing, that caused my client harm. And that's why you will find that the best trial lawyers are ones who can try and win the case in the deposition, the pretrial testimony, and why it's so critical to ask these hypothetical questions. You know, I realize you're watching this video because you have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need answers first, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.